Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi. And she yells, oh, girl, you gotta hear this one. A man was arrested for running a theme park. And when they said, where's your license? He said, my dog ate it. Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her Prosecco, makes fun of all the weirdos, and then I hear her shout, girl, you gotta hear this one. Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, you'll never guess what's true with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, girl, you gotta hear this one.
Anyway, getting to what this stream is actually about, I will cut that first part and I will make it a separate stream because I was not planning on doing a stream about Charlie Kirk until tomorrow night, where I have other people where I've been talking to who are going to join me for that. However, what we are here to do is finish the Carly Gregg appeal document. And we are going to get to that and get through it because we're on page 47 of 75. So there's that. And there will be some things on this stream that will be changing, on this channel that will be changing. As much as I like to hear other people's opinions, I'm not going to be afraid to yeet people. My mods, the minute someone gets disrespectful, they get one warning and they get yeeted after that. You let me know who you yeeted for 24 hours and I will yeet them permanently because I'm not tolerating disrespect. It's just not, I don't know. I don't get paid enough to tolerate some people's bullshit. Like, just, yeah, I don't get paid enough for that shit. Nobody gets paid enough for that shit. All right. And before I get threats and stuff, I just eat you. Bankruptcy judge Preston case filed a new order. Are you going to be doing a Hales update today? I was going to, but the person who was disrespectful to me in the comments is a Hales supporter, and I don't want them anywhere near me. So, but I did, before I eat them, I did put in my comment, I will give you a chance to respond and correct whatever, if I was or misinterpreting the fact that you insulted me straight to my face and disrespected me. I interpreted that as a blatant disrespect. But I will give someone the opportunity to work things out and discuss things with me before I completely eat them, because I do try to be respectful in that part. But I don't know if I want to do a What the Hales update because I'm kind of sick of that shit. All that, like, yeah, I'm kind of sick of, excuse my bluntness, but I'm kind of sick of the hypocrisy in this country And one of the reasons that the Hales case was interesting to me was because the it's a microcosm of society. It's one side thinking they're completely right, and when both sides suck. Sound familiar? Both sides suck. Everybody sucks. No one's perfect, but one side thinks not the person, but the supporters think that one side is completely right and is literally doing the same shit as the other side, but can't see past their own nose enough to see it. And that comment left in my comment section was a perfect fucking example. And excuse my language, I am very on fire. The little is not in here. She is out with her father. So I'm going to light it up today. And now that I'm thoroughly annoyed, um, I am going to light up these lawyers because this shit is fucking ridiculous too. All right, we were at issue 4. The prosecutor made improper and highly prejudicial comments during closing arguments and sentencing phase of the trial. As discussed in issue 3 above, immediately following the jury's verdict of guilt on counts 1, 2, and 3, the trial court immediately went into the sentencing phase of the trial. The trial court asked the state to call its first witness, although the state declined and simply offered to submit argument. During said argument, the state made several highly improper comments that we submit would require resentencing. That right there. You bearded man Steve, you put it perfectly. Both sides go to the extreme and blame the other side. And there's a few people who don't. It's not everybody. We don't generalize completely, but it's a large percentage. While some of us just sit in the middle and go, yeah, y'all are fucking nuts. Y'all are fucking nuts. Parole speculation. Barred by Marks Williams. The most egregious of the improper comments made by the prosecutor during the argument in the sentencing phase was the following. If she is given the possibility of parole, no one in this room knows how long she will stay there. We cannot guarantee she will stay there 1 year or 10 years. We have no control over that. Not only was this statement by the prosecutor patently false, and the prosecutor knew it was false, footnote 13, but Mississippi has consistently disapproved of argument which discusses potential punishment of a defendant. Although it is well established in Mississippi that attorneys are given a wide latitude in arguing their cases to the jury, one tactics which are inflammatory, highly prejudicial, and reasonably calculated to unduly influence the jury are not permissible. Manning v. State, citing Hyder v. State. The appellate court in Manning went further, stating that it is well settled in Mississippi jurisprudence that closing arguments which discuss the possible penalty of a defendant can receive is improper. Citing Marks v. State, the standard review of which our appellate courts must apply to allegations of lawyer misconduct during opening statements or closing arguments is whether the natural and probable effect of the improper argument is to create an unjust prejudice against the accused so as to result in a decision influenced by the prejudice so created. This is the first argument that they've made that I don't disagree with. I'm not sure how I feel about a lot of their other arguments, but this one I'm kind of seeing. I don't know what they want from it and which sentences must be vacated, but this one might actually stand a chance. Like I said, not a lawyer. This is just my personal opinion based on just reading and logic. Squid just sent you a DM. Please look at it later. It's for possibly tomorrow if you wish. Hugs. Thanks, Cynthia. Incidentally, we know that these statements affected the jury's deliberations. That's that statement, we know they did. Well, how do you know? Do you know? Did you talk to the jurors? Did they tell you? How? This is where it's like try to be persuasive, but all I do you really know? It just makes me ask more questions of you, which is not a good thing. The more questions I ask, the more I don't believe what you say, generally speaking. If I just listen to you or read it and I'm like, "Okay, that makes sense. That makes sense." But if I start asking questions and I start looking deeper and I don't believe you. And their consideration of whether to impose life or life with parole, as they submitted a question to the trial court inquiring, "What is life in prison without parole, years-wise?" Well, that doesn't necessarily they say they impacted their deliberations or their considerations. They just had a general question because it's a general question. It's a general question. Footnote 13, at an out of presence jury instruction conference, the court and counsel discussed the real-world effect of parole eligibility. No one suggested Carly could be released in as little as a year. Yet in summation, the prosecutor warned that if Carly were parole eligible, we cannot guarantee she will stay in 1 year or 10 years. Injecting a specter she knew or should have known did not exist to inflame rather than inform the jury. Counsel cannot state facts which are not in evidence and which the court does not know or appeal to the prejudices of men. Mm. By injecting prejudice not contained in some source of evidence. The sentencing phase. In Marks v. State, our Supreme Court stated we have consistently disapproved of arguments which refer to the potential sentence in a given case. Citing Williams v. State, reference to the possibility of parole should the defendant not be sentenced to die are wholly out of place. Smith v. State, Mississippi 1969, improper to argue that finding defendant not guilty by reason of insanity would result in his being released in once found sane. Hartville v. State, prejudicial error to tell the jury that a manslaughter verdict or life sentence would amount to no punishment at all. Abney v. State, reversible error for the prosecutor in urging a unaliving conviction to state that the maximum penalty for manslaughter is 20 years and the minimum is in the discretion of the court. Minor v. State. Ooh, they're going back all the way to 1911. And hey, Tammy. Hey, Jen. Reversible error to state in a closing argument that if manslaughter verdict is brought in, judge does not have to sentence defendant to the penitentiary. In an unaliving case, it is improper for a prosecutor to argue in closing arguments about the punishment that can be imposed. But I believe this was if I'm remembering the trial correctly, all of this happened in the sentencing phase, not the guilty or innocence. This was all in the sentencing phase. So that's the only thing. Once again, not a lawyer. No one's ever mistaken me for a lawyer, right, Lisa? However, the people who know more than me are going to be in my comment section. I would assume there is a difference between a sentencing phase and what you can talk to the jury about in a sentencing phase and just the end of a trial looking for a guilty or not guilty verdict. That would be my educated guess, just based on logic, because in a sentencing phase, you're literally trying to convince the jury to lock them up for as long as possible. Just a thought. But I'm kind of on a bitch mode today, so that might be Yeah, sometimes I think clearer when I'm in a bitchy mood, but ugh. In a close case such as this, close case, close case, she was on camera. You heard the shot where her mother screamed. You heard her mother's last moments on camera. She was the only other person in the house. They never argued that she didn't do it. They just argued that she was insane at the time she did it. So, close case my backside. Uh, and people that know less than you in your top oh, that dude. There's a variety, I like both, but it's the people who know less than me but think they know more than me that's the problem. Her argument that judge could sentence defendant to a term in a penitentiary for manslaughter was a very fine bid for a conviction of manslaughter. Inflammatory fear-mongering, barred by Hyder Manning. The second highly improper and inflammatory comment made by the prosecutor in summation was the following. If she were paroled, nothing would stop her from walking into a school, a shopping mall, a grocery store, or the movie theaters. I mean, where's the lie? It 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 might be inflammatory, but it's true. That's the thing about the truth. You might not always like it, and it might not be pleasant to hear, and it might piss people off. But guess what? That doesn't make it any less true. Just like the article that I read before this, just because you don't like what the man wrote on stuff, and just because it seems to align with one side of the political aisle and not the other side, doesn't mean doesn't mean that you get to downplay that. And you get to call what people said about him hateful and fear-mongering because you might not like it, but it's the motherfucking truth. I don't know why I was talking to her. She rage quit. Hey, Sonia Chris, obligatory comment for the algorithm because YouTube is so appreciate it. And I'm not sure how to feel about that. I'm not sure if that's actually true, but you know, it is what it is, so I appreciate it. They were arguing she could get death in prison or imprisonment until she was too old to be a danger. Um, so she was 15 at the time of the trial. She was 14 at the time of the crime. TLDR with the crime, she unalived her mother and attempted to unalive her stepfather. She was 14. 15 at the time of the crime. So Supreme Court obviously can't, well, not obviously, but Supreme Court decision, you can't subject a minor to the death penalty, cruel and unusual punishment. So she was charged with first degree unaliving and then second degree attempted unaliving and tampering with evidence because she put the camera in the freezer or the fridge, one of the two. She put the camera that was in the kitchen in the refrigerator to try to hide it from cops because it showed her with the weapon. And then getting on the phone and on her mom's phone and texting her stepfather, "When are you going to be home, honey?" So, after her mom had already passed. Yeah, it's so they were arguing life in prison without parole or parole. So, it also veer it also veers towards an improper golden rule style plea by inviting jurors to imagine future personal danger. The prosecutor's litany, school, shopping mall, grocery store, and movie theaters, explicitly asked jurors to envision themselves and their families as prospective targets and to punish Carly to protect the community. This last part, okay, whether what this prosecutor did was appropriate or not, we have to remember a couple of things. One, the defense attorneys never objected to it. And second, um, isn't the whole point of sentencing is to punish the defendant and protect the community. So using these two words or these two phrases in their brief is not very persuasive to me because that's the whole point of sentencing. Just my personal opinion. Like that's just my personal opinion. But yeah. Okay. Life in. Okay, I misread your comment. I apologize. Life without parole equals death in prison. Yeah. Hey, Joe. Well, what about Ethan Crumley, the Oxford school shooter? He was trying to his adult and he has no parole in his defense. Attorneys fought it. The prosecutor wouldn't budge. And that's if you were here with us yesterday when we were reading through it, that was my criticism of their other arguments so far. Their other arguments so far all had to do with her being a minor and not having a minor not being subjected to life in prison without parole. And they were bringing up the fact that she was a minor, but she was charged as an adult. So here would be my argument if I was a lawyer. And James, you can let me know what you think of this. Because this would be my argument if I was a lawyer and if I was given this in like a debate class and I was told to debate why she should get life in prison without parole. My argument would have been, even though the cases that you were citing talk about minors being charged, one, it's minors who were charged with non-unaliving crimes, for one, and it's minors who were charged as minors. They were charged as juveniles. When you are charged as an adult, my thought process would be, and how I interpret laws would be, laws that apply to minors don't apply to you anymore because you're being charged as an adult. In the eyes of the law, you are no longer underage. So there's that. You take that one how you will, but that would have been my argument against this. So this is their appeal. They're appealing directly to the Mississippi Supreme Court. So we will see how it goes. That's the classic golden rule rhetoric. It invites verdict based on a personal fear rather than a record of evidence. But here's the, okay, this is going to be a stream. It's going to be one for the record books. It invites a verdict based on personal fear rather than record or evidence. They already had a verdict. So they're citing stuff that doesn't apply. In my opinion, reading this as a layperson would be, you're bringing shit up that doesn't matter because it invites a verdict. They already had a verdict. This was sentencing phase. This had nothing to do with the verdict. She was found guilty. Suck it up, Buttercup. You lost. Rather than record evidence or the Miller factors. It also sends a message to appeal community alarm, which our court forbids as inflammatory and unduly prejudicial. See Hyder Manning in a juvenile, here they go again, in a juvenile life without parole context, where individualized consideration is constitutionally required. This sort of speculative future danger argument is especially improper and warrants a new, properly conducted sentencing hearing. She was charged as an adult. Like, take the juvenile arguments to me are like the mental gymnastics that they have to do to make this shit make sense. Like, I'm sure that state has a youthful offender statute regarding defendant youth. I know Florida, Georgia, and South Carolina does. Mississippi does too. However, does it apply to youth tried as youth? Does it apply to youth who are charged as juveniles, or does it apply to juveniles who are charged as an adult? There's the million-dollar question and the argument that I would be raising, because the judge in this case, I love the judge in this case. He was no nonsense. He cared about his jury. but she was being charged with an adult, so he treated her as an adult. He treated things as she was 18 and in court. So I'm wondering, that'd be the argument that I would use to argue against this. Would be, yeah, you do adult things, you do adult prizes, and even I know people who. Okay, I've worked with some pretty violently mentally ill individuals who still were able to tell me right from wrong. They knew their actions were wrong and they did them anyway. Mm. It's specific to juvenile charges and adult. The statute here was very vague in it didn't explicitly say. So really, this would be better presented to the governor for commutation. So I'll have to look up the statute again. They posted part of it here, but the part that they post here didn't specifically say anything. The last 50 pages have not specifically said anything about. They've left out the fact that she was charged as an adult, which to me, it's when we go through articles and we read different articles on the same topic and we see what one media outlet isn't telling you, it's not what they're telling you, it's what they're leaving out. 75 pages of information, and they're leaving out the fact that she was charged as an adult. To me, leaving out the fact that she was charged as an adult when you're arguing that she is a juvenile it's a big deal to me. That's I don't know. It's a big deal to me. It might not be a big deal to everybody, and it might not be a big deal to the appellate judges, but it's a big deal to me. Misstatement of the governing sentence law for juveniles. The following statement was improper and clearly a misstatement of the law in context of the sentencing phase of the trial. Quote, in the eyes of the law, Carly Gregg is an adult. In Florida, youthful offender statute gives hearing requirements, trial, and sentencing guidelines. Mississippi, I'm not entirely sure, but in this brief, they did not put anything like that. They did put for juveniles, but they did not put anything about for juveniles charged as an adult. And that's where I'm a little leery of these lawyers, because they did not put anything. They did put hearing requirements. What was the hearing? This is page 50. So they did put. See, for the purposes of this section, juvenile offender means a person who has not reached the age of 18 at the time of the commission of the offense. But they never put anything about any of this in this statute that they name. They never put anything about juveniles who are charged as adults. That's where I'm hinky. And Carmen Spawn of AJ, thank you for the $5 super chat. Happy Friday. Happy Friday to you as well. I hope you are doing well. And it's good to see you. Hey, Dad, how are you? Oh, Dad, if you want me on fire, go back to the beginning of this stream. Watch the first 10 minutes. If you want to see me pissed off. For those of you who don't know, I scared my father yesterday. Probably for the first time in my life. So, hey, Lisa. I've been popping in and out, catching up in the real world. 3D life always takes precedence over YouTube. Always. All right, so we were on page 50. We are going to scroll back down. And I'm sorry about your eyes. Close your eyes. I'll let you know when we're there. There we go. The following statement was improper and clearly a misstatement of the law in context of the sentencing phase of the trial. In the eyes of the law, Carly Gregg is an adult. For Miller sentencing, the law is opposite. Children are constitutionally different from adults for the purposes of sentencing. Youth youth, its hallmarks must be given meaningful weight before life without parole can be imposed. See Miller v. Alabama. Telling the jury she is an adult risks misleading them about the Miller framework and is further evidence that the entire sentencing phase of this trial was fatally flawed. And here is my problem with that, because they never mention about juveniles charged as adults. They always say children are constitutionally different from adults for the purpose of sentencing. But they never specify, are these juveniles that are charged as juveniles who are constitutionally different, or are they juveniles who are charged as an adult? And to me, that is the hallmark of this entire document. That runs through this, and I mentioned it like 10,000 times. I was pretty much beating a dead horse yesterday with the amount of times I was annoying people with saying, but she was charged as an adult. They never mention it. So I would have to look at the statute closer, but it's just it doesn't something there's something missing here, and I think that's what it is. But I think if they put that she was charged as an adult in this, that it would destroy their entire argument. And I think that's why they're leaving it out. I think three appellate lawyers are smart enough to know what to put in a document and what to leave out. And I have the feeling, my assumption would be that they left that shit out on purpose. Hi, Angel. Based on the foregoing, we respectfully contend that the natural and probable effect of the improper argument by the state created unjust prejudice against Carly and resulted in a decision influenced by the prejudice so created. And it was invigorating. And I don't want to be directly rude to that person, because that subjects me to being on to their level. And I don't want to do that. And that's one of the reasons that I'm not naming their names. If someone is just directly rude to me all the time, and has only been rude to me, but this person has been in my chat for she left around the time of the election because she hated my politics, but then came back. But now that I'm bringing up my politics again, in a way that's generally I would say not judgmental of anybody who disagrees with me, unless they're violent. That's where I have the problem. Yes, and it's my birthday, so I'm getting a little ornery in my old age. And I love the people who are making fun of me, like, she's so mad she's turning 40. No, I'm making fun of it. It's because I make fun of myself. If you make fun of yourself, nobody else can make fun of you, because their opinions don't fucking matter. All right. To the extent the trial court or counsel did not lodge contemporaneous objections, this court should review the prosecutor's parole speculation and community alarm pleas for plain error. Mississippi appellate courts may correct clear and obvious errors that affect substantial rights and seriously compromise the fairness and integrity of proceedings. Her lawyers in this case were a personal injury lawyer and a DUI lawyer. Nothing personal against them, but Bridget Todd, I really don't like you as a lawyer. You might be good at your personal injury, but as far as trying a murder case, you sucked. You sucked ass. And this appellate document is actually kind of proving my opinion correct, because these appellate lawyers, even though I might not agree with their arguments, one of their arguments that I do agree with is the trial counsel did not lodge objections. You should have. Your appeal would be taken much better if you would have launched objections. Even if your objections were overruled, that is why even though some people joke and have an objection counter on their channels, rehab or recovery addict, I love that you do that. Even when objections are overruled, they can still be used in appellate purposes. Eh, yeah. Yeah, other people's ill-conceived ideas and judgments of me are none of my business. Yep, live by that too. Um, it's, it's it's one of those situations that your emotional immaturity is not my problem. Uh, Cameron, I had to go back and watch the beginning. Sounds like we've been having the same morning, people being grinding my gears. Hardly ever get mad, but sheesh. I know, I don't usually get mad, but, like, when you come on my channel and you personally insult me and call me a liar, then I'm like, "R hold slow your roll, slow your roll." When you call me a liar with no evidence, just because you don't like what I said does not make me a liar. It just makes you not like my opinion, which is fair, and I'm okay with that. But to call me names and personally attack me on my own fucking channel, fuck that shit. Like, do you see a bunch of people that are no longer on this channel and no longer in this chat because they're no longer welcome here because they tried creating drama and I said, "Fuck you, bye, don't talk to me anymore." Like, fuck that shit. Oh, my birthday is not for another 13 days, but I'm because it's my 40th, I'm spending the whole month. You know what I mean? I'm giving myself the whole fucking month, uh, because of the fact that it's 40 and I'm cranky. Uh, uh, Miller allows life without parole. And James, I know I've probably asked this. You're a lawyer, but where or what kind? That I've never asked. Uh, and if you don't need to tell me where, but like general like area of the country. Um, the review had to consider the defendant's youth, mitigating factors, the nature of the crime before sentencing defendant to imprisonment with no hope for parole. Is that in Mississippi though? Because and what about and my big question and the one that I'm not sure about because I haven't seen it in Mississippi statutes that I have looked at. Um, I have to bring up the last time I looked at Mississippi statutes were when she was charged, and when she was her trial, which was September of last year. So I streamed this trial before I was monetized. Um, However, the last time I looked at it, I don't remember seeing anything. You're not a lawyer? Right. Well, did you sleep at a Holiday Inn last night? I'm just kidding. Um, it the question that I have and that I have not seen in the statutes of Mississippi, like Jeff had brought up about Georgia and Florida, juveniles are considered a juvenile even when charged as an adult. Mississippi, I have not seen anything that and they did not put it in there, and the trial court did not say treat her like they did say treat her as an adult, but that's all they said. They didn't say anything about the statute to make it clear that juvenile sta statutes, juvenile laws, rules, hearings don't apply to her because she was charged as an adult. That's one thing that I am so curious about. So, but is that as a defendant who was charged as an adult or a juvenile who was charged as a juvenile? There's the million-dollar question that I can't seem to find an answer to. Like, I'm, you know what I mean? Like, that's the there's the one that I can't find an answer to yet. I'm sure we will, but, like, yeah. And I preface this, Gail, I'm sick of people cheering at such tragic things evil. I am not cheering for this child. Well, I know what you're talking about, but we're just gonna transition to this and put that comment towards this thing. Um, when I say that I hope she spends the rest of her life in jail, that is not me, and that is not, like, this channel advocating for throwing children in jail, but, like, even people with mental health problems, depression and anxiety, mental health problems, know the difference between right and wrong. She unalived her mother. It is a this person needs to be away from people, and then called a friend and said, "Have you ever seen a dead body?" And invited her friend, her 14-year-old friend over, or 15-year-old friend over to see the dead body. The SCOTUS cases were tried as an adult case. Yeah. So, hey, Larissa. Lurking, commenting for the algorithm. I appreciate everybody who is commenting for the algorithm. I have not seen exactly where that is stated, and I've seen people both sides, of that argument where it is and it isn't. However, I appreciate the effort and the support of doing it just in case. So, I appreciate the one thing that I will say, James, is I have a problem with the fact that juvenile offenders, when they're convicted, or even before they're convicted, when they're in jail, are in solitary. I have big problems with that in the sense of that to me is cruel. That because that's a punishment for adults. They get in trouble, they go to solitary. So you're punishing this child just for being a child. Yes, she did adult things, but it's it's one of those that's where I have the ethical concerns and the yeah. So, mm, oy. The state's assertion that no one knows how long she will stay there and if that paroled is nothing would stop her from entering schools, malls, groceries, theaters were both inaccurate and calculated to inflame, diverting the jury from the Miller factors to forbidden speculation about parole and future danger. I this is this is where I think that this will be a problem for the state. So, in Mississippi, a juvenile can get life without parole if charged as an adult, but the U.S. Supreme Court states a judge must prove they are beyond rehabilitation. Is that what you're asking? Kind of, kind of. It there this in this brief they never put that she was charged as an adult. So there's my they keep mentioning the fact that all these mitigating factors for juveniles, but in the case law that they had mentioned above, they mentioned like armed robbery, burglary. They never mentioned a juvenile that was charged with that was charged with first degree unaliving. So it's a it's a it's a big thing. Uh, oh, and I did just get confirmation from a guest for tomorrow night. So tomorrow night, 7 o'clock. 7 o'clock, we will be talking Charlie Kirk. But we will be talking about it from the aspect of social media and creators. But I did hear back from somebody that I asked to be on this channel, and I think y'all will be pleasantly surprised with it's a secret. And I'm kind of in the I'm so glad that they said yes, but I'm kind of in the I'll believe it when I see it, so I don't wanna get my hopes up because 'cause I'm excited to have this person on my channel. So, uh, just came back from watching the start of the stream, holy crap. Yeah, I was a little fired up. I got a little fired up. Hmm. I started the stream a half an hour early so I could get that out of my system. Yeah, the only reason that I'm not saying is specifically because I will believe it when I see it. Because I've followed this creator for a while. I like what they have to say. I I listen to them quite frequently, and I'm like, I'll believe it when I see it. Oh believe it when I see it. All right. Sorry. Uh, Given the stakes, a potential life without parole sentence for a juvenile, the prejudice is manifest and warrants a new Miller complaint sentencing hearing. Based on this alone, I think she will get a sentence. She will get a resentencing hearing, or at least this will go to oral arguments, and we will hear both sides. So, yeah. Hey, it's so Griffiths. Had to work late. Just got here and watching now, even though it's not Hales. LOL. Love you, Squid. Thanks. And is that a University of Miami T-shirt on your Muppet family there? Like, yeah, I didn't believe in true evil since hearing all these cases. There is real evil, and that's another reason why I want to. That's a reason we talk about stuff like this. Is it's hard to talk about. This is a kid who unalived and attempted to unalive. Her stepfather was shot in the shoulder, like like while they were wrestling with the weapon. Like, do you know how easy that would have been? Just a couple inches in the wrong direction, and you are gone. Um, so when we call each other names online, when people are on social media and they're using inflammatory language like this person's a Yahtzee or this person's, the dude from Germany in the 30s with the little mustache, the ugly ass little dude. Um, when you're calling people all these ists and evil and this, shit like Charlie happens. This is actual evil. When someone in cold blood unalives one of the person who gave them life. Yes, her father had stuff to do with it too, but her mom grew her. Like, this is actual evil. This is why we got to stop calling people evil who don't agree with us, because this is actual evil. This shit right here is actual evil. Being able to take the life of somebody else and not give a flying fuck is evil. Calling your friend, have you ever seen a dead body? And showing off your mother's corpse to your friend? Texting your stepfather and saying from your mom's phone, "When are you gonna be home, honey?" And trying to unalive him too? That's calculated. That's evil. Not agreeing with who you voted for president is not evil. Does not make somebody evil. Sweet baby Jesus. This is why I talk about shit like this, because this shit is pure evil. Ugh. Anyway, back to it. Alternatively, relief is warranted under Strickland v. Washington. According to Mississippi courts, the standard of review for a claim of ineffective assistance involves a two-pronged inquiry. The defendant must demonstrate that his counsel's performance was deficient and that deficiency prejudiced the defense of the case. I do believe that her counsel was I do feel like her counsel was ineffective. And to the person who just emailed me, thank you. I read the first few sentences and thank you. I'm not, I'll read your email and I'll respond to you when I'm done. But I appreciate the email. So in case you're lurking, thank you for that. All right. The first prong takes into account whether an attorney's actions or inactions were reasonable under all the circumstances, and considering whether such conduct was a result of trial strategy. No reasonable strategy supports allowing the prosecutor, 1, to misstate parole consequences, 2, advance golden rule community alarm hypotheticals, and 3, press for juvenile life without parole without objection or a request for curative instructions. And once again, I am not a lawyer, so I'm not judging lawyers. Um, I'm not I'm not judging lawyers and where you choose to practice. Do not do not take that, because I know people infer things when you don't say stuff. Um, However, when you hire a personal injury attorney and a DUI attorney to do a murder trial, and they've never done a murder trial before, I am convinced that criminal defense attorneys are criminal defense attorneys for a reason, because they have a specific skill set that they've worked on and they've honed for years. And when they did their first murder trial, they probably were with someone who had already done unaliving trials, and they sat second chair and they learned. They didn't just jump into a unaliving trial head first. I have never actually spoken to Larry, DUI guy, and I have never spoken to lawyer Goodhair. Um, the lawyer you know, but the lawyer you know does personal injury. Larry does DUI. I have never personally spoken to either one of them. However, I'm sure if I asked them the question, "Hey, would you take an unaliving trial when you've never done one before?" And you would be with someone who's also never done an unaliving trial before. Both of them might be hesitant to do it. I'm not putting words in their mouth. I'm just assuming, because they are very knowledgeable people, that they would be a little hesitant to take a trial of this magnitude when they've never done something like this before. It's like practicing OT. Occupational therapy, I was in acute care. If you sent me to a pediatrics clinic, I'd be like, I don't know what the hell I'm doing. Yes, I have a degree in occupational therapy assistant, but I have no idea what I'm doing. Don't, help me, please help me. I'm lost. I'm in over my head. You take, just even in acute care, you took some of the therapists who spent all of their whole career, or lots of their career, uh, on a cardiac floor in the cardiac ICUs, and you put them in a neuro ICU, they get lost. They're like, I don't wor I have a basic framework of what to do because I'm a therapist, but I have no idea. This is not my area of expertise. It's not the area I practice. I don't know what I'm doing. I need help. I can't imagine that it's much different for a lawyer. Like I said, not a lawyer, but I can use my medical experience, my medical background, to infer what it would be like as a lawyer who practices in one area to get thrown into an area where you're not familiar and be like, okay, I, I know I'm a lawyer. I have the knowledge of like the basic framework of what to do, but eh, yes, even if you were hired as a lead lawyer, you should want a co-counsel who has done similar cases. And it's yeah, it's weird that Mississippi actually allows an experienced capital life murder case without an assigned co-chair. Yeah, one of them, and I think Bridget Todd was the personal injury, and I think the other guy or the guy was a DUI. They might have been switched, but I believe Bridget Todd was the personal injury lawyer. But neither one of her lawyers were criminal defense in the unaliving game, or the violent crime kind of, you know, aspect of it. It's one of those things that makes you just go, "Huh?" Like, I'm sure Mississippi has plenty of lawyers. Like, even my small town had 3 or 4 law firms. Like, yeah, town of less than 3,000 people had quite a few law firms. Ugh, ugh, ugh. Oh, and Jeff with the child corn, um, there's a case in my old town that if I didn't want to completely dox where I lived, I would be covering, because ugh, I might send it to somebody else for them to cover, because it's bad. Ugh. Case in the Anthony attorney was not experienced. Judge assigned a local capital attorney to help him. Interesting. That did not happen here. That did not happen here. Um, mm, I believe her counsel was ineffective, and I believe she has a case for ineffective counsel. I don't know what that'll lead to, but I believe that her lawyers failed her. Uh, Counsel also failed to insist on a true Miller hearing, or at a minimum, a continuance to marshal mitigation witnesses as evidence tailored to the Miller factors. This performance fell below an objective standard of reasonableness, and there is a reasonable probability that, but for counsel's errors, the result would have been different, at least life with parole or deferral to a judge for term sentencing. The combination of an abbreviated, unprepared hearing and uncorrected, prohibited argument undermines the confidence in the sentence and satisfies both Strickland prongs. Issue 5. To the extent that Carly's sentences is to be construed as life without parole as imposed by the jury, this sentence was against the overwhelming weight of the evidence and unconstitutional under Miller and its progeny. Assuming arguendo, Carly's sentence as to count 1 and count 2 is life without parole, it cannot withstand constitutional scrutiny under Miller v. Alabama and Montgomery v. Louisiana. In Miller, a 14-year-old was sentenced to life without parole after he and others were convicted of unaliving a neighbor after a group of them have gotten high and intoxicated on alcohol. The Supreme Court held that the sentence was unconstitutional, noting the court's Eighth Amendment jurisprudence requiring proportionality in sentencing. Okay, y'all can feel free to give me your opinions on this, but Miller, is not a proportion, like, a 14-year-old sentenced to life with parole after he and others, after a group of them have gotten high and intoxicated. Two things that don't fit with this case. She was not with a group, she was by herself, and she was not intoxicated. So proportionality, like, so you them citing proportionality, like, there's my mind goes to proportionality. She was alone, calculated, and not intoxicated. The court cited its prior decision in Roper v. Simmons, which held that the death penalty for those under 18 is unconstitutional. That I agree with. Following that logic, the court held life without parole for juveniles itself is tantamount to the death penalty. Consequently, the court held that mandatory life without parole sentences for juveniles violates the Eighth Amendment because juveniles' diminished culpability and greater prospect for reform. They are less deserving of the most severe punishments. Maybe for attempted unaliving, because no one actually unalive, the victim in that case is still with us. But for unaliving cases and first-degree unaliving, there's a fine line here. And this is one of the things that's going to be interesting with this, and why, when this came out, I wanted to read it. We've been waiting for this. The court continued, they are less deserving of the most severe punishments. The court further explained, first, children have a lack of maturity and underdeveloped sense of responsibility, leading to recklessness, impulsivity, and heedless risk-taking. Second, children are more vulnerable to negative influence and outside pressures. This right here is why people try to get to them in school. Why people try to shape the way they think when they're young, because that's really hard to change. Including from their family and peers. They have limited control over their own environment and lack the ability to extricate themselves from horrific crime-producing settings. And third, a child's character is not well formed as an adult's. His traits are less fixed and his actions less likely to be evidence of irretrievably depravity. Daddy. Okay. uh Come here, baby. Come here, baby. Shh. It's okay. Say hi. You say hi. It's okay. All right. Consequently, the court held that principle of individualized sentencing is paramount when considering life without parole sentencing of minors. This requirement requires the minor be given individualized consideration of all factors in sentencing, as explained by the court. Our individualized sentencing cases teach that imposing a state's harshest penalties, a sentencer misses too much if he treats every child as an adult. To recap, mandatory life without parole for a juvenile precludes consideration of his chronological age and its hallmark features, among them immaturity, impetuosity, and failure to appreciate the risks and consequences. Like stepping on our toys hurts our feet, right? It prevents taking into account the family and home environment that surrounds him and from which he cannot usually extricate himself, no matter how brutal or dysfunctional. It neglects the circumstances of the homicide offense, including the extent of his participation in the conduct and the way that familial and peer pressures may have affected him. Indeed, it ignores that he might have been charged and convicted of a lesser offense if not for incompetencies associated with youth. For example, his inability to deal with police officers or prosecutors, including a plea agreement. I preface that with she turned down a plea deal, or his incapacity to assist his own attorneys. And finally, this mandatory punishment disregards the possibility of rehabilitation even when circumstances most suggest it. The court also noted that a sentence of life without parole of a juvenile is reserved for those juveniles with an irreparable corruption, which must be found in an individualized consideration by the sentencer of all these factors. The court reaffirms and elaborated on its holding in Miller v. Montgomery v. Louisiana, where a defendant had spent nearly 50 years in prison for a crime committed when he was 17 years old. Further elaborating on Miller, the court cognitively stated, Miller had held that mandatory life without parole for juvenile homicide offenders violates the Eighth Amendment's prohibition on cruel and unusual punishments by making youth and all that accompanies it irrelevant to the imposition of the harshest prison sentence. Mandatory life without parole poses too great a risk of disproportionate punishment. Miller required that sentencing courts consider a child's diminished culpability and heightened capacity for change before condemning him or her to die in prison. Although Miller did not foreclose a sentencer's ability to impose life without parole on a juvenile, the court explained that a lifetime in prison is a disproportionate sentence for all but the rarest of children whose crimes reflect irreparable corruption. I'll help you. I'll help you.
Where's that?
There you go.
Oh, this.
You're welcome.
Uh-uh.
You want to get down?
No.
Okay.
Yeah.
Hey, General.
Hey.
Squid little appearance to add some cuteness to such serious business. Are you cute?
Mm-hmm.
Yeah. You're sweet. Are you sweet?
Mm-hmm.
Mm-hmm. Mm-hmm. Here.
Mommy,
And
put over here.
hands. There you go.
Put over here.
Water.
Mm-hmm.
The overwhelming weight of evidence in this case demonstrates not irreparable corruption, but mental illness, transient crisis, and treatability, none of which were adequately considered. Friends and teachers described Carly as affectionate, intelligent, and socially connected, precisely the kind of adolescent whose conduct reflects immaturity and illness, not permanent incorrigibility. Even the state's psychiatrist testified that she is not a psychopath or evil, while the defense expert documented bipolar disorder, psychotic spectrum symptoms, and dissociation that stabilized under treatment. Her stepfather, the victim of her assault, testified she appeared out of her mind, scared, terrified, with huge eyes. Yes, because she just unalived somebody. Like, the state's response will be interesting, I believe. I can't wait for that. Hi, Daniel. Underscoring that the offense arose from crisis, not a fixed and callous disregard for life. I kind of beg to differ. Miller forbids sentencing such a juvenile to die in prison. As the Supreme Court held, only the rare juvenile offender whose crime reflects irreparable corruption may constitutionally receive life without parole. To impose life without parole here, in the face of abundant testimony showing Carly's redeemability and responsiveness to treatment, is against the overwhelming weight of the evidence and violates the Eighth Amendment. We now turn to address the Miller factors in turn, demonstrating the lack of Hey, Chris. I hate this word. Just for we're all on the same page. Contained within the record. No evidence of permanent incorrigibility under Miller and Montgomery. Life without parole is constitutionally reserved for the rare juvenile whose crime reflects irreparable corruption, not whose conduct stems from transient immaturity. Speaking of transient immaturity, Montgomery v. Louisiana. Nothing in Carly's record approaches that showing. The state's own psychiatrist disclaims psychopathy and evil. Defense evidence documented bipolar, psychotic spectrum, and dissociation that stabilized with treatment. Lay witnesses described Carly as affectionate, intelligent, socially connected, classic indicators of her capacity for reform, not fixed depravity. Her stepfather's account that she appeared out of her mind, scared, terrified, with huge eyes, is inconsistent with the cold, remorseless profile that might support the rarest category. Hi, Angel. Prosecutorial assertions of zero remorse are argument, not proof of permanent incorrigibility. On this record, life without parole exceeds the constitutional limit. Factor 1, age and its hallmark features. Angel, you're silly. Angel, can you go put this in the freezer?
No.
You gotta take that to Daddy if you want to play with it. Indicia. Inks. I always want to say indices, and it's like, nope, that's not it. My brain and my mouth say two different things. And thank you, Heidi. Squidlet's laughter and voice is heartwarming. Yeah, it's heartwarming and loud. It's loud. Carly was 14. The very features Miller tells this court to weigh: immaturity, impulsivity, risk-taking, and limited appreciation of consequences were amplified here by acute, treatable mental illness. Nothing suggests unusual adult-like maturity or planning sophistication that would cut against youth mitigation. Or planning sophistication. I don't know, like when you walk back into the kitchen, having the weapon behind you so it can't be seen on camera. That sounds planning. Grabbing your mom's phone, texting your stepfather from her phone to ask what time he'd be home. That says planning to me. But hey, to each their own. Factor 2, family and home environment. Even the state acknowledges serious family strain, substance issues with her father, undercutting the prosecutor's perfect home life narrative. The point under Miller is not to blame the family, but to recognize the environments from which a child cannot usually extricate herself. The record reflects precisely the kind of instability that counsels against the harsh penalty. Factor 3, circumstances of the offense and pressures. Evidence points to an acute crisis episode rather than calculated, profit-motivated, or sadistic violence. Contemporaneous observations of terror and dissociation, and medical proof of psychotic spectrum symptoms. All place conduct in a transient illness-driven frame. No evidence of gang pressure, leadership in criminal enterprise, or sustained course of predatory behavior. 4, youth-related incompetencies in the system. Carly was sentenced immediately after the verdict with no pre-sentence investigation, no time to marshal mitigation witnesses, and no meaningful opportunity to develop expert mitigation, precisely the sort of youth-related limitations in decision-making and legal navigation Miller flags as salient. 5, possibility of rehab. This record affirmatively shows treatability, symptoms stabilized with medication and treatment, and the state's expert rejected the very diagnosis, psychopathy evil, most predictive of non-rehab. That evidence is the opposite of irreparable corruption. Process matters too. Even after Jones v. Mississippi, sentencer must follow a certain process considering an offender's youth and attendant characteristics before imposing life without parole sentence. Discretion alone is not enough. It must be exercised meaningfully. Here, there was no genuine individualized Miller assessment, no PSI, no mitigation, no reasoned findings tethered to the 5 Miller factors, only an immediate post-verdict disposition, life without parole imposed on the skeletal showing that cannot be squared with Miller, Montgomery, and Jones. Bottom line, stripped the bare facts that homicide occurred, the evidentiary record contains no proof, let alone the rare, compelling proof of permanent incorrigibility. Every Miller consideration either weighs against life without parole or never meaningfully developed. The sentence is overwhelmingly the weight of the evidence and unconstitutional under the 8th Amendment. The court should vacate and remand for a Miller-compliant resentencing at minimum. Part 2, deprived of a fair trial. Issue 6, trial court committed reversible error by prospectively denying any request for continuance without evaluating the circumstances that might arise during the proceedings. A malignant narcissist can exhibit those type of facial expressions and behaviors when caught in the process of doing or actions already committed in panic modes or to manipulate the situation. There's that too. To get out of pain for said actions. This was one of the first and most telling abuses of discretion, and it colored everything that followed. At the very first pretrial hearing on June 4th, 2024, and I believe I do have a video of that in the Carly Gregg playlist. During the court's initial exposure to the case, the court noted September 16th, 2024 trial date and warned that this court does not continue cases. The colloquy continued, I appreciate Mr. Smiley's position, but I'm just going to be frank. Y'all have heard me say it today. It's not y'all's name that gets run in the newspaper if something happens. It's mine. This case is set for trial in September. I see no reason why this case can't be tried in September. The court then reiterated, I want to make this clear. Y'all have heard me say this multiple times today. This court does not continue cases. So if you need that order, you need to go ahead and apply for it immediately. We respectfully submit that this categorically advanced refusal to consider a continuance was an abdication, not an exercise of discretion. It framed every subsequent ruling, prioritized the calendar over case-specific needs, and set the stage for errors that followed. The U.S. Supreme Court has cautioned against a myopic insistence upon expeditiousness in the face of a justifiable request for delay. I don't believe in the documents that I have that she ever filed for a continuance, ever. So, thank you for this, Heidi. The following excerpt from Leonard v. Leonard is directly on point and extremely instructive. The granting or denying of a continuance is ordinarily a matter committed to sound discretion of the trial judge. Reversal on appeal is considered seriously only where failure to grant a continuance represents a clear abuse of discretion. Okay. Any court which has an automatic policy that in a certain type of case requests for continuances are not granted by this court under any circumstances is not exercising discretion. It is acting arbitrarily and capriciously, and its actions in this regard are entitled to little immunity from reversal. Although no party formally challenged the court's blanket no continuances stance at trial, once again, they didn't ask for continuance ever. This court may and should review the error under the plain error doctrine because it permeated the proceedings, including the pressuring Carly into intrusive mental evaluations before she had properly put sanity at issue. Plain error applies where error results in a manifest miscarriage of justice or seriously affects the fairness, integrity, or public reputation of judicial proceedings. Connors v. State, quoting U.S. v. Atkinson, a prospective across-the-board refusal to consider any continuance, regardless of circumstances, was error, and on this record, seriously affected the fairness and integrity of the proceedings. My problem with that is they never asked for it, so you don't know if he actually... It's one of those things of like, he said, well, we don't grant continuances. Well, they never asked. So it's one of those situations where you never know. So this is a hypothetical argument because I never actually asked, as in the documents that I have. I don't believe that I have, and these documents are all in the Discord. So these documents I'm looking in the Discord now in the case document. There is a Carly Gregg section. Order to disclose reports, media at trial, docket entries. There is never a waiver of appearance. There is never an request for a... I'm looking at the docket entries. Date of last filing was 7/24/24. Scheduling order, motion for discovery, notice of appearance, docket annotation, attorney advised to refile due to incorrect attorney name, miscellaneous document, camera coverages, motion for bond, motion to exclude, motion for miscellaneous relief, discovery disclosure, motion to change venue. They wanted to transfer it to a youth court. Notice of attorney appearances on behalf of Court TV. Another notice, response in opposition to transfer to a youth court. Motion for mental examinations. They never put in a motion to continue this case. Motion to exclude, letter, subpoena returned, notice. I'm looking at 46 docket entries so far, 50. Motion to compel, mental evaluation, miscellaneous relief, a bunch of subpoenas. Yeah, they never once put in an order in 80, 90. Motion to exclude, hearing transcript, 108 docket entries. So here's 108 docket entries. They never filed. I'm not showing it because they have names of witnesses and stuff, and I'm just not. I'm not about that. So I'm not about showing, especially underage witnesses, names. And I can't remember who the underage ones were compared to the above age ones, so I'm just not showing it. However, 108 documents, not one of them was a motion to continue or for a continuance. Therefore, this is all hypothetical. Yeah, he said that, but if you have a true issue that needs a continuance, I'm sure the judge would be like, this This judge strikes me as the type that I'm not going to offer continuance because you're going on vacation. Like that kind of situation. The scheduling posture was not just background, it drove substance. To preserve the September trial date, the court moved from a blanket no continuances stance to a coercive pretrial orders that short-circuited the rules. Without the predicates required by Mississippi Rules of Criminal Procedure 12.2 and 17.4, the court compelled psychiatric examinations and broad disclosure of a defense-held medical records, conferring a tactical advantage on the state and forcing premature exposure of defense strategy. If I remember correctly, the defense didn't comply with a bunch of stuff. So the defense didn't comply with discovery deadlines, if I'm remembering this correctly, and the judge was not happy. But yet they never put in a motion to continue. They never asked for it. Obviously you're not going to get it if you never ask. The next section details why those orders exceeded the court's authority and violated the core constitutional protections, and why the resulting prejudice warrants relief. 7. Trial court erred by compelling psychiatric evaluations absent the findings required by 12.2 and 17.4, thereby abusing its discretion and depriving her of a fair trial. Ugh. How are they going to use an argument lack of assessment when it was her own defense who filed to stop a mental health evaluation requested by the state during all of this? Yeah, there's that. This trial was, her counsel was not effective. Let's just call it what it is. So she does have a case for ineffective trial counsel, which would be interesting to see because I've never actually seen that work before. By motion filed June 17th, 2024, the state sought an order compelling Carly to undergo a mental evaluation. The motion expressly conceded that Carly had not yet met the requirements of an insanity defense, and instead relied on the assertion that the defendant alleged mental health concerns, claiming to be incompetent to stand trial. The record reflects the pretrial discussions about Carly's mental health, but we find no statement by Carly or defense counsel declaring her incompetent to stand trial. And even assuming arguendo that such a statement had been made, it would not satisfy the procedural prerequisites for ordering an intrusive sanity at the time of offense evaluation. After a hearing, a conditional agreement by defense counsel, the court ordered both a competency exam and a McNaughton insanity evaluation. In its July 3rd order, the court compelled a criminal responsibility exam, not because Carly noticed an insanity defense, but because she may raise one. Since the defendant herein may raise an insanity defense, the mental evaluation of a defendant is to include an investigation and analysis of defendant's mental condition at the time of the alleged offense. In accordance with MRCP 12.2, that language shows the court anticipated a possible insanity defense, and to keep the September 2024 trial date intact, ordered a state-ordered sanity evaluation in advance so the prosecution would have plenty of time to prepare rebuttal. That doesn't sound like a... correct me if I'm wrong, but that just sounds like a prosecutor being able to anticipate the defense, what means the defense is predictable. That's not a... I don't know. They probably should have had their own psychiatrists and psychologists, even though I don't think psychologists meet Daubert. I think they... You mean the defense? I think they did. I think they did. They did. It's just... Yeah, an anticipation. Yeah, you're predictable. Like, I don't know, somebody in Florida, Pro Hoc Vice in Florida, and wondered why when he filed a motion that a Florida lawyer would file, by the first name Randy, would file a rebuttal or a response within a day. He already had these motions probably like 3/4 of the way written. or had an idea what you were going to do because your playbook is predictable. You are predictable. And when you are predictable, people can anticipate your moves and can do stuff before you do and get ahead of you. Sorry, but it's gamesmanship. Half of being an adult is gamesmanship. Getting ahead of things before other people. Like winning an argument is knowing more than the person you're arguing against. It's just it kind of seems logical to me, but hey, I could be wrong. Footnote 14, the record reflects that trial counsel agreed that the state should have Carly evaluated, but only after Carly had been evaluated by the defense expert. The sequencing is opposite what Rule 12.2 contemplates. By its terms and designs, Mississippi Rules of Criminal Procedure 12.2 conditions any court-ordered criminal responsibility exam on a triggering act by the defense. Okay, the rule says it has to be triggered by the defense, then they broke the rule. Even if it's anticipated. Help you with what? What do you need help with? Oh, girl, you're getting heavy. You're getting heavy. See, Stevenson v. State, stating that Stevenson had intended to allege insanity defense, the correct criminal procedure would have been for Stevenson's defense counsel to serve a written notice.
No, mommy.
Hey, oh, hey, Ann. Oh, I'm feeling okay. I get an IV once a month, to stay ahead of my headaches and stuff.
Mommy,
Angel,
I said.
you're gonna help? You're gonna use your mouse?
Yeah.
Okay. You use your mouse right here. Okay.
Mommy.
I'm sorry to interrupt the stream, but her saying "okay, mommy" is by far the
Okay.
cutest thing I've ever heard in my life.
So you have done.
Yeah.
Day. Bye.
But how are
Okay.
you doing, Ann?
Bye. Bye, Judy.
You got your. You're gonna scroll through.
No, he's done.
Okay.
Sorry.
The correct criminal procedure would have been for Stevenson's defense counsel to serve a written notice of the intention to offer a defense of insanity, citing 17.4, only after a notice and typically upon the state's motion and showing of a need. May the court order exam directed at the defendant's sanity at the time of the offense. The July 3rd order inverted that sequence. It conflated an ordinary competency inquiry with anticipatory sanity evaluation and invoked Rule 12.2 without predicate of the defense notice. In practical effect, the court compelled disclosure of defense strategy, enabled the state to marshal rebuttal experts and tailor its case, all to keep the September setting intact. I don't think it had to do with this. I think it had to do with the fact that their playbook was obvious. You got your ice? Hey, living life. Oh. Uh-oh. All while depriving the defense of the timing and confidentiality protections the rule affords. Once again, that's ineffectiveness of counsel because they didn't argue it. They didn't argue the fact they let the judge do it. So it's kind of like it's an ineffective counsel. That's not the judge's fault. That is ineffectiveness of counsel. Girl, you're silly. Footnote 15. In addition to recognizing that the insanity defense had not yet been properly raised, the July 3rd order failed to articulate any reasonable grounds to believe that the defendant is mentally incompetent, showing Ah,
Hi, mommy. Hi, baby. Hi, baby. Hi, baby.
sorry.
Hi, baby.
Oh,
Hi, baby.
mama first, YouTuber second. Oh my goodness. Oh, oh, sit down. I am sitting down. You gonna sit down? No. Okay. Sit down. Her favorite phrase. Daddy, sit down. Daddy, sit down was her first sentence. So, before even a competency examination can be ordered, this premature court-initiated 12.2A and B exam was an abuse of discretion and structurally unfair for several reasons. No reasonable grounds supported a competency exam under Rule 12.2A. 12.2A authorizes competent exam only if the court, on its own motion or the motion of any party, reasonably grounds to believe the defendant is mentally incompetent. The state's motion did not supply such grounds. It relied on a mischaracterization asserting the defense claimed incompetence when it did not, and the fact that the defense retained a private evaluator. Retaining a consultant is not a reasonable ground to believe present incompetency, and absent concrete facts, observations, history, or behavior, the predicate for a compelled competency exam was not made. The court's order for incompetency/insanity evaluation likewise cited no reasonable grounds upon which to believe that Carly was incompetent, as required by 12.2. In fact, immediately after the July 2nd hearing, the state's motion for mental evaluation, the court held its obligatory monthly juvenile justice detention hearing. During that hearing, the court noted only issue with regard to her present mental state was prior testimony regarding self-harm of this particular juvenile while she was not incarcerated. That was her cutting. However, the court had heard of no such danger while she was incarcerated. This seemingly contradicts any assertion that the court had reasonable grounds to believe that she was mentally incompetent, as is required by the rules. Sanity at the time of the offense under Exam Rule 12.2 requires defense notice under Rule 17.4. May is speculation, not notice. 12.2b permits mental responsibility, the McNaughton exam, only if the defendant has timely raised a defense of insanity pursuant to 17.4b. Until the defense actually notices that affirmative defense, the state has no entitlement to probe the defendant's mental state at the time of the offense. Here, the state conceded that Miss Gregg had not yet made requirements of an insanity defense and merely predicted she will make that argument. I mean, perhaps the state should have waited. Yeah, you know. The prediction does not satisfy Rule 17.4b and cannot trigger Rule 12.2b, ordering a retrospective sanity evaluation in the absence of notice exceeded the rule's text. The order improperly conflated two distinct inquiries. Competency and criminal responsibility are distinct. MRCP 12.2, 17.4b, the court leapt from any purported competency concern to a full McNaughton analysis, expanding scope based solely on a prediction of a possible defense, not a proper predicate. D, the compelled exam ordered before the defense placed a mental condition properly at issue raises Fifth and Sixth Amendment concerns. This might be an interesting argument. Compelled psychiatric examinations intrude upon the privilege against self-incrimination and the right to counsel. The prosecution's ability to obtain and use such an exam exists only after the defendant actually places a mental condition at issue. This might actually be a problem for the state. Even though it was predictable, you still got to wait your turn. You can start lining up your experts. You can start talking to people and what she's going to do and start prepping for that, but to actually have a hearing on it, and the state might have overstepped their bounds on this one, which sucks because I believe she's guilty and she deserves life in prison without parole. But hey, a rule's a rule. And it is what it is. Like, as much as I want her to be behind bars for the rest of her life, if you don't follow the rules, you don't follow the rules, you don't follow the rules, you don't follow the rules. Sucks to be the state. Which is one of the reasons that the state should be held to a high standard, because I would rather have a guilty person be resentenced or have a new trial than watch an innocent person go to prison for the rest of their life. So it's kind of one of those things of the state. They have a point. I don't agree with a lot of their arguments, but this one I'm kind of feeling like is one of the other ones that might work. I know this document's 75 pages. We're almost through it, though. We're on page 62. By notice or by offering psychiatric evidence, see Estelle v. Smith, use of uncounseled, compelled psychiatric statements violates the 5th and 6th. Buchanan v. Kentucky states rebuttal permitted only after defense opens the door. You can have everything ready, but you can't actually mention it to the court until the defense does. And they did. Hey, Janet. Kansas v. Cheever, same principle. Here, because no insanity notice had been given, the order prematurely compelled statements and impressions the state would not otherwise receive, raising classic Estelle concerns. Moreover, the order's sweeping privilege waiver extending to medical, psychiatric, psychological, education, dependency, addiction, and employment records was also overboard and unnecessary to any properly cabined competency inquiry, impining recognized privileges and privacy interests beyond what any rule authorizes. Structural unfairness and tactical tilt to the state by forcing Rule 12.2b type evaluation in early July against a September 16th trial setting, the court afforded the prosecution a head start to secure rebuttal experts. They could have started securing rebuttal experts without informing the court. Like, they don't have to, they can start talking to people. Like, you can start sending out emails or whatever you do. Hey, I might have a case where, you might be, they can do whatever they need to plan for this defense without actually informing the court and writing a motion and making it official. There's a little ethical concern there, but you can make a strategy without actually acting on the strategy. You can have in mind who you want to be your expert. Oh, I know this guy. This guy's testified for the state before in this and this. You can start maybe not securing your witnesses, but having your rebuttal witnesses in mind. It's not hard. I mean, they've tried enough cases where they have enough experts to be like, okay, we can call this guy for this. We can call this guy for this. Start getting in mind who you want to without actually writing and breaking the rule in the court. It's just common sense and logic that sometimes I think the state gets a little overzealous with wanting to be ready and prepared, that they get a little overzealous. Why the judge let that happen, I have no idea. But I think that they have a really good argument here. Preview the defense theory and script cross-examination while pressuring the defense to reveal or abandon a potential insanity theory prematurely. That timing advantage distorts the adversarial balance of the rules are designed to preserve and is not curable by later limiting instructions. Further, the compelled evaluation chilled confidential consultations with defense experts, risked derivative use of compelled statements, and forced strategic disclosure before Rule 17.4b's decision point. Once disclosed, those statements and impressions cannot be unseen. Once you ring that bell, you can't unring it. Moreover, compelling the defense to produce medical records in its possession can also trigger a Fifth Amendment active production problem. The production itself tactically admits existence, possession, and authenticity. See U.S. v. Hubble, By ordering Carly to undergo both competency and insanity examinations absent the procedural prerequisites, the trial court acted outside the bounds of its discretion. This amounted to an abuse of discretion and was a violation of Carly's constitutional rights of epic proportions. Little slight there. Mississippi courts have long held that the judicial discretion is not unfettered, but must be exercised in accordance with established legal standards. See Terrell v. State. The court's ruling here improperly expanded Rule 12.2 beyond its plain terms, compelling an intrusive psychiatric examination without the factual predicate required by the law. We respectfully contend that this was further evidence of the court's intent to rush this case to trial to avoid putting the state in a position to request a continuance as to obtain the rebuttal expert opinions. Ruling in favor of the state and ordering the intrusive competency and insanity evaluation, the trial court mistakenly relied on Ballard v. State. However, Ballard does not dispense with Rule 17.4b's written notice requirement. The trial court cited Ballard to suggest that formal written notice of an insanity defense is unnecessary to invoke the court's coercive power. Interesting. This I find really interesting, because I thought this was a really good judge and he ran his courtroom really well. However, I'm finding issues with Judge Arthur in maybe they did rush it. I mean, but even though nobody put in a request to continue the case, maybe they should have. But is that a judge problem, or is that a defense problem, or a prosecution problem? Like, I'm open to being wrong with my opinions. I just need evidence as to sway my opinion. And this is kind of swaying my opinion. I don't know. This is one of the first appellate documents that I've read where I'm like, they might have a point. They might have a point. And it was like, oh, that's unfortunate. But that is why everybody is entitled to an appeal, because there is shit going on that the average person, even the average juror, does not know about. And this is why everybody is entitled to an appeal. Although sometimes, like in the instance of Sarah Boone, I think it's dumb. Everybody's entitled. That misreads the case and the rules. Ballard addressed an evidentiary ruling excluding a defense expert's ultimate McNaughton opinion on the ground that his report lacked the magic words. Applying URCCC 9.04 and MRE 103, the Court of Appeals reversed because there was no unfair surprise. The state plainly knew insanity was the defense and presented its own expert to rebut it. Ballard neither considered nor approved a court-initiated mental responsibility exam before the defense placed sanity at issue. By contrast, the current Mississippi Rules of Criminal Procedure squarely control here. 12.2 authorizes a sanity at the time of offense exam only if the defendant has timely raised a defense of insanity pursuant to Rule 17.4, i.e. by written notice. The July 3rd order compelling the McNaughton analysis absent any Rule 17.4b notice is therefore beyond the rule's grant of authority, and Ballard proves no safe harbor. Here, unlike Ballard, the defense had not noticed insanity under Rule 17.4 at the time of the court ordered Carly to undergo a competency and sanity evaluation. The state's motion rested on a prediction that the defense will assert sanity on the fact that the defense retained a private evaluator, neither which constitutes the Rule 17.4b notice or 12.2a reasonable grounds to doubt competency. Compelling a July McNaughton exam on the record both exceeded Rule 12.2b's textual predicate and conferred the very tactile tilt Ballard sought to avoid, handing the state a preview of the defense while locking in the September trial setting. I mean, even though that might have been predictable defense, you still got to comply with the rules. And it sounds like they didn't. nor was a court-ordered premature 12.2b exam necessary to avert trial by ambush. Rule 17.4b sets the notice deadline at the pretrial motions date, August 30th of 2024, and expressly contemplates the court's discretion for later notice upon good cause. If after the defendant timely notices insanity, the state believes it needs additional time to evaluate or secure rebuttal expertise, the proper and far less drastic remedy is a continuance or adjusted deadlines, not a speculative court-initiated sanity examination in advance of any notice. Magic words like abracadabra. Yeah, that'll work. Ugh. I don't know. This part of this document is swaying my opinion. I mean, it's kind of it's kind of plain to see you didn't follow you didn't follow the rules. Like, I don't know how to you can't defend the state and or the court in this situation. They didn't follow the rules. This is another instance of the court subordinating Carly's rights to its calendar, insulating the state from having to seek a continuance the court had pre-announced it would deny. Due process, forcing a mental responsibility exam before rule predicates violates fundamental fairness. 14th Amendment and Article 3 of the Mississippi Constitution guarantee fundamental fairness in criminal proceedings. According to the Fifth Circuit, the conviction of a defendant after a trial is fundamentally unfair whenever the cause of such unfairness violates the 14th Amendment due process. Fitzgerald v. Estelle, citing the mob domination cases, Frank v. Magnum, Holmes, J. Dissenting, and Moore v. Dempsey. The conviction of accused person while he is legally incompetent, Pate v. Robinson, and a conviction predicated upon no evidence at all, Thompson v. City of Louisville. Whenever a defendant has been convicted as the result of such a gross malfunction, the result is that the state's criminal justice system has operated to deny due process. So that footnote, the trial court scheduling order as it pertains to pretrial motions is as follows. Parties must file pretrial motions with the circuit clerk, and either personally or electronically serve counsel opposite before 5 p.m. on the 30th day of August 2024, or they will be deemed waived or abandoned for that reason. Synthesizing the foregoing, we respectfully submit that forcing Carly into a court-ordered McNaughton evaluation before the rule predicates were met made the proceedings fundamentally unfair. The order inverted Mississippi sequencing. There were no Rule 12.2 reasonable grounds to doubt competency, and Rule 17.4 written notice of an insanity defense to trigger any sanity at offense exam under Rule 12.2b. Yet the court compelled an intrusive examination that extracted testimonial statements, previewed defense strategy, and via sweeping records waiver, pierced privileges that protected the attorney-client and psychotherapist relationship. That shortcut created grave risk of erroneous deprivation and irreversible strategic prejudice. Once the state and its experts hear compelled statements and impressions, they cannot be unheard, and the tactical tilt cannot be cured by later instructions. Yes, 30 likes. Great job, thumbs. I appreciate everybody who hit that like button and who came in and left a comment. Even the lurkers who usually lurk or who left a comment for the algorithm. I appreciate you guys. I know sometimes when you're watching, especially when you're watching on TV, it's really hard to you can't comment from a TV. It's a little cumbersome to actually hit the like button. You kind of got to do a little maneuvering with the remote. I get it, but I appreciate it. And to all the people who unsubscribed from me because I have a different opinion than you, may you have a good life. Ugh. By contrast, less restrictive alternatives were obvious and adequate. Wait for a timely Rule 17.4 notice, or if notice is given and time is tight, grant a short continuance, so the court's choice was unnecessary to any legitimate governmental interest in docket control. In short, by skipping the rules, safeguards, and harvesting compelled mental responsibility evidence on speculation, the court allowed the adjudicatory system Say that 10 times fast. To operate in a way that was structurally unfair, violating due process. Based on the foregoing, we respectfully submit that Carly's convictions should be reversed and remanded for a new trial. I don't disagree. I don't disagree. I mean, the trial court erred when it allowed Rebecca Kirk to summarize the book Crime and Punishment over objection of defendant. We've gone over this. This is not new. This was mentioned in many pages above. During rebuttal, State questioned Counselor Rebecca Kirk about a treatment note stating Carly will read Crime and Punishment after Kirk had said Carly was reading The Castle, which Kirk herself did not know very well and had mentioned the bell jar. The prosecutor then asked Kirk to tell us what Crime and Punishment was about. Defense objected at sidebar as irrelevant and unduly prejudicial, noting Carly had disclosed she had not read the book. The court overruled and the defense objection was allowed the prosecutor to proceed. My thought process, and y'all can feel free to disagree with me as usual. She put in an order and she talked to her about reading this book. Not so by her summarizing what it was about is more along the lines of why did you want her to read it, not looking into her psychology of why she read this book. Like I have the brain book. Why did I choose that book to read? It's more of why would I tell somebody to read that book? That is why the judge overruled it, in my opinion, because it had nothing to do with Carly's and speculating on Carly's mental health at the time. It was, why did you want her to read it? In front of the jury, Kirk delivered a lurid synopsis describing a psychopath, a student who plans a hatchet murder, kills 2 people and writes about why people kill, is declared insane and served 8 years unrepentant in a Russian labor camp. She then admitted her underlined title in the note was just for grammar, not clinical emphasis. It had been misrepresented to the trial judge by the state. My comment stands as support for all your hard work. Cheers, Squid. Thank you so much. All right. Kirk further conceded the note reflected Carly had not yet read the book on 2/21 and that she only thinks Carly read it later over spring break. Allowing this testimony was an abuse of discretion. The plot of a 19th century Russian novel is not a fact of consequence in this case. There was no foundation that Carly read it. Any minimal probative value was substantially outweighed by the danger of unfair prejudice and juror confusion given the mirrored themes of murder and insanity. I mean, you bring up a good argument, but I don't know if it's enough. It invited improper propensity inference from Carly's supposed interest in dark literature and was not tied to any reliable clinical method or opinion from this non-insanity expert. The decision of a trial court to admit or exclude evidence is reviewed under an abuse of discretion standard. Burgess v. State, citing Whitaker v. State, Smith v. State, though an abuse of discretion standard affords great discretion to the trial judge, this court has not hesitated to invoke its authority to order a new trial and allow a second jury to pass on the evidence where it considers the first jury's determination of guilt to be based on extreme or weak, tenuous evidence. Coleman v. State, admitting inflammatory and or prejudicial proof that does not tie the accused to the charged offense is an abuse of the trial court's discretion. Holding that the trial court erred in admitting the towel allegedly containing the defendant's man juice because the state's failure to positively connect it on the towel to the defendant rendered the towel inadmissible. That was not a That was not a sentence I was prepared to read today. Um, hey, Sir Frank, how are you? I love your new picture. Uh, the New Jersey Supreme Court affirmed the appellate division's reversal of a conviction where the state had a witness read pages of the defendant's violent rap lyrics to prove motive and intent. State v. Skinner. In so holding, the court held the lyrics were highly prejudicial and carried little or no probative value because they were expressive, fictional writings not tied to a strong nexus to the charged shooting. This is like people who got pissed in Miami over Steve's book. I have not read his whole book, that whole book, the Steve Gosney, but people were pissed off because of a couple passages in there, even though it's a work of fiction. So this I can sort of see the logic, but I don't know if that's going to be a strong enough argument because I just don't know. But I agree with this line of thinking just because someone thinks something and writes something in a fictional book doesn't mean that's what their personality is. Like, doesn't mean that and yet YSL got put on trial for their lyrics. Yeah, isn't it like an art is not a fictional book is not your true inner, like, it's not your personality. And just because you write something in a book that might not be like that might be a little 50 Shades of Grey-ish, does not mean that the writer of 50 Shades of Grey is into that, if you know what I mean. Like it's so there's a difference between art and life. In so holding, the court held that lyrics were highly prejudicial and carried little or no probative value because they were expressive, fictional writings not tied to a strong nexus to the charged shooting. Part of that court's reasoning can be found in the following passage. Difficulty in identifying probative value in fictional or other forms of artistic self-expressive endeavors is that one cannot presume that simply because an author has chosen to write about certain topics, he or she has acted in accordance with those views. Somebody needs to copy this, and I need to copy this and send it to Steve, because this reminds me of his situation when he moved to Miami. One would not presume that Bob Marley, who wrote the well-known song I Shot the Sheriff, actually shot a sheriff, or that Edgar Allan Poe buried a man beneath his floorboards as depicted in his short story The Telltale Heart, simply because their respective artistic endeavors on those subjects. Defendants' lyrics should not receive no different treatment. In sum, we reject the proposition that probative evidence about a charged offense can be found in an individual's artistic endeavors, absent a strong nexus between specific details of the artistic composition and the circumstances of the offense for which the evidence is being adduced. Like, I know. And I don't mean to, like, bring that up to, like, run his name through the mud, because I love Steve. I have one of Steve's books. I have one of Steve's children's books. And it's the only reason it's not quite kept with the rest of Baby Squid's books is because it's paperback. And we're still in the destroying phase of books. But I have read it to her, and I do like it. But just because Steve writes something in a different book, not this book, that might not be everybody's cup of tea, shall you say, does not mean that that's how he feels about people. Like, you know what I mean? Like, just, ugh. But Steve is a really good guy. I'd actually love to talk to him. He seems like he'd be fascinating to talk to. Applying 404B, 403 type analysis, the Skinner court emphasized expressive works risk poisoning the jury by suggesting bad character or propensity. My only problem with them bringing this up is that these were works that people themselves did and then were charged with crimes. Carly did not write this book. She was told to read this book or advised to read this book. Yeah. Some of the book, however, was exposing some realities behind the scenes in various states, but not a reflection of Godney's character as a person whatsoever. That's what I remember him saying. Yeah, Steve is a great person. Yes. And like I said, this has nothing to do with Steve. This has nothing to do with Steve as a person. This passage from this court made me think of the Ghazni situation. And because how I remember things is I connect things that I see in documents to situations that I know in real life, and that's how I understand them. And that's how I process and understand things, is to connect it to stuff I already know. That's how I graduated from college. I would connect stuff to, like, I passed physics by connecting it to figure skating because I figure skated. So I would connect everything that I learned in physics to how it connected with me on the ice. That's the way I remembered how to pass physics. So derailed. Oh, but I'm still mad about the Miami Blue Hairs having a shit fit. I know, me too. Me too. Yeah. But this passage made me think of that situation, and yeah. So, but yes, I have the doggo book. I'll show you guys it in a little bit. I have one that's signed. So that's one of the reasons I don't let Baby Squid have it, is because I don't want her to root it, because it is signed. And she's in the destroying books still. We're in the cardboard book phase still, because we don't know how to turn pages without ripping pages. Such material is admissible only when it directly connects to the specific facts of the offense, like if you unalived somebody and then wrote a song about it. Courts must weigh whether less prejudicial evidence can make the same point, and even when admissible, careful redaction and limiting instructions are required. The New Jersey Supreme Court concluded by affirming the appellate division's reversal and grant of a new trial based on the erroneously admitted evidence. Turning the case to sub judice, there's some of these words I hate. Like, my brain can read them and I understand what they mean, but my mouth cannot physically say the words. Allowing the counselor to summarize the novel, especially when there was a dispute over whether Carly even read it, presented expressive fictional content with no concrete linkage to the charged acts. Like the lyrics in Skinner, the plot summary had at best minimal probative value on any genuinely disputed material issue and a substantial danger of unfair prejudice. It invited the jury to equate Carly with a psychopath protagonist who plans and commits an unaliving, encouraging propensity and moral condemnation and inferences. If this was written by itself, this part about the book and this whole thing, I probably wouldn't give it much weight. However, this and the preceding 15 pages yesterday, what I read yesterday in the part 1 of this, I did not think that this document stood a chance. These arguments, I'm thinking that this document stands a chance. So it's one of those things of like, this document today, I'm feeling a little bit different than I did yesterday. The state also had less prejudicial avenues to explore treatment or mental state topics without invoking a 19th century murder narrative. Under Skinner's framework, demanding a strong nexus, careful Rule 403 balancing, considerations of alternatives, and restraint with artistic expressive works, the trial court's decision to overrule the objection and permit the plot description was an abuse of discretion because it was irrelevant or marginally relevant and far more prejudicial than probative. The Mississippi Supreme Court in Blanc result in Jordan v. State, affirmed by an equally divided court with Justice King's detailed objection, shows why admitting the counselor's plot summary of Crime and Punishment was an abuse of discretion. King emphasized that courts must exercise rigorous gatekeeping with inflammatory, expressive material and exclude it absent a strong nexus to the charged facts. Otherwise, its unfair prejudice overwhelms any slight probative value. a concern squarely governed by Rules 401 and 404B, and ultimate filter of Rule 403. Jordan faults the trial court for admitting expressive content without proper foundation or review and for allowing the jury to be exposed to material that stoked propensity inferences. Errors present here when the court let a witness recite a lurid plot, psychopathy, hatchet murders, insanity, with no showing that Carly actually read the book or the story bore on a material disputed issue. See Jordan as relevance, 403 as ultimate filter, failure to review exhibit for admitting, authentication foundation deficiencies, heightened prejudice from artistic works, reliance on Skinner, prejudice substantially outweighs probative value, abusive direction requiring reversal. Mississippi precedent likewise condemns admitting violent lyrics art where the link to the crime is tenuous. Fictional expressive works inadmissible absent a strong specific nexus. Under these authorities, the court should have limited the testimony to non-prejudicial therapy context or excluded it. Allowing a plot synopsis invited exactly the kind of propensity reasoning Jordan and Brooks warn against. Another somewhat analogous case is U.S. v. Curtin. In an online incitement case, the government sought to admit 5 graphic stories found on the defendant's PDA to prove intent, preparation, knowledge, and modus operandi. Although 404B is an inclusory rule, the Ninth Circuit held such inflammatory expressive material can be admitted, if at all, only after rigorous 403 balancing, and trial judge cannot do that without personally reading the proffered writings in full. The court faulted the district judge for admitting the stories, despite the extraordinary potential to inflame the jury and invite conviction for proclivity, rather than the charged conduct. The opinion emphasized possession of a lawful reading material is not a bad act. Even when the writings are arguably relevant to intent, court must demand a strong specific nexus. Basically, you need to have proof that they used it. Otherwise, the admission is an abuse of discretion. Like the stories in Curtin, the state used expressive fictional content to suggest propensity here, having the counselor recount the plot of a novel about a psychopath who plans and commits murder to imply Carly's character or mindset, but there's no strong nexus to apply to any genuinely disputed material issue. And the court did not undertake the kind of searching Rule 403 screening Curtin requires. If anything, this case is even more prejudicial. The jury actually heard the sensational plot summary, which risked moral condemnation by association with a murderous protagonist when the same therapeutic points could have been explored through neutral, less prejudicial testimony about treatment. I don't disagree. Yeah, I'm liking their arguments here. I really am. It's called Crime and Punishment. And there was no proof that she actually read it. So I am actually thoroughly enjoying these I'm thoroughly enjoying this argument. I mean, it's long, don't get me wrong. We're on page 72. We're almost done. We're almost done now. Y'all, we're almost done. 5.5 hours of this. 2 hours from yesterday and 2.5 hours today. 4.5 hours. Yeah, yesterday's argument I wasn't so hot with. Just the fact that she was a juvenile, she's juvenile, blah, 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 all that stuff. I was questioning it constantly. This argument makes sense to me. The court didn't follow the rules, and the court allowed that. At first, I was like, so the court let that in, big deal. And now I'm like, what they're saying is making sense to me. Once again, I'm not a judge, let alone an appellate judge. But, I mean, it's a sound argument for a new trial. Maybe we'll have a Carly Gregg 2.0. I'd be very interested to see how that goes. And if she gets lawyers that are actually criminal defense attorneys who have done unaliving cases before. Based on the foregoing authorities, the court's decision to let the counselor summarize the plot of Crime and Punishment was an abuse of discretion, warranting reversal. Like the inflammatory artistic works condemned in State v. Skinner, the book summary had a negligible probative value, lacked any strong nexus to the charged acts, and merely bolstered the state's narrative despite other less prejudicial proof of motive intent and carried a substantial risk of poisoning the jury. The Ninth Circuit's en banc ruling in U.S. v. Curtin likewise requires trial judges to review and carefully limit or exclude literary material and bar it when Rule 403 prejudice predominates, gatekeeping that did not occur here. Mississippi law points the same way. Brooks v. State reversed where violent expressive material untethered to the crime slipped in without adequate Rule 403 balancing. And the Jordan and Bonk writings caution that highly charged rap content with tenuous links in the case is unduly prejudicial and easily misused. Last issue. Yeah. She needs lawyers that are actually decent and not, oh, she's a little kid, we just need to dress her up like she's 5. Yeah. Oh, yeah. Thanks for bringing that up, Sir Frank. Before we get to this last issue, she literally dressed the entire trial like she was 10 years old. Like she was a little doll. And trying to make her seem as young and innocent as possible. It was creepy. It was almost to the creepy level. Because I don't think any 10-year-old would wear that. We're talking like early to mid 90s stuff. It was just creepy. 10, cumulative error requires reversal. Mississippi's cumulative error doctrine recognizes that individual errors not reversible in themselves may combine with other errors to make up reversible error. This I'm finding this might work. Where there are several errors the court may reverse, even if in standing alone none would warrant reversal. Rubenstein v. State, individual errors not reversible in themselves may combine with other errors to make up reversible error, where the defendant was deprived of a fundamentally fair and impartial trial. The question is not whether any single misstep was independently outcome determinative, but whether the aggregate effect so infected the proceedings with unfairness as to deny due process. This record presents multiple interacting errors that cumulatively undermined both the reliability of the sentencing and fairness of the trial. Yes, them old porcelain dolls. Yes, porcelain dolls. Yes, there we go. Thank you. I thought of the 90s because my mom had some of those porcelain dolls, and I swear she dressed me up for a couple of Easters. I have a picture of me that's so miserable in a dress like Carly Gregg with Mary Jane's and everything. Creepy. This case was tainted by compounding errors that together denied Carly a fair and lawful sentencing. First, we're not going to go through all of these. They highlight them again. 5th, 6th. Conclusion, they respectfully, based on the propositions cited briefed above, together with any plain error noticed by this court, which has not been specifically raised, the catch-all. I didn't notice it, but you might have. But may appear to the court on a full review of the record, the judgment of the trial court and her conviction and sentences should be reversed and rendered, or alternatively reversed and remanded for a new trial. Or alternatively, they give a lot of options here. Remanded for resentencing within guidelines of 97-3-21-2. Respectfully, in this matter, remanded to the lower court for further proceedings. So these are her James Murphy, Lance Mixon, and Bradley Clanton. I mean, those James Murphy doesn't sound like much, but Mixon and Clanton sound like Mississippi or very old Southern names, if I do say so myself. So it's this should be interesting. This should be very, very interesting. Just yeah. Yesterday, I was convinced that this was not going to go to a new trial. Today, I'm not sure how I feel. Today, I'm very conflicted. Need to head back to work. Everyone, don't forget to hit the like button and just do better. Yes, do better. It wasn't Vices who always said do better. We need to take the words Vices and just do better. Do better. Just do better. But I am going to check the docket for I'm going to check the docket for what am I going to check the docket for? Pacer, just to see, and we will see if we are going to do a what the hell stream in a few minutes. Yes, it was our law racks that said that, and I live by them words. I miss law racks. Things were different. Things were much different and much better when he was around. I miss him very, very dearly. He has no idea. And although I am glad that we have Connor, I am also very sad that he is not here with us right now, because he was my biggest cheerleader. He was my biggest cheerleader. Your mom's always busy. It was nice finally being able to hang out with you. I got to go get ready for my mom's stream. I'll be the host tonight. She's busy. She's always busy. But what time is she going live? Cuz we can redirect over there. Yeah. I am checking the Pacer the dockets in Federal 1, Federal 2, and the bankruptcy, because James was here a little earlier and said that there was an order from the judge. 6 Eastern? All right. Let's see. We're at 100. Let's go 200. And when I'm on this, I just check all. If I'm going to check one, I just check them all right away. So, but I have my saved cases. Oh, and I do have an update in Hannah Dugan. She filed for a reconsideration of that judge's nice 97-page report. Okay, so the only thing that is in, I will show you guys the docket, and I will show you guys the what is here. That way I can just cut this and we can just make this as a separate, because there is no actual document. And I'm sorry I can't make it any bigger, but it says final notice to file proof of service. Jerome Ramsaran is hereby reminded the requirement to serve the document referenced herein and file a certificate of service within 3 days. Failure to comply with the Florida NB notice, Florida North bankruptcy noticing requirements may result in the hearing being canceled and or the matter being denied for failure to comply with noticing requirements. And it says re-35 notice of hearing. There is a hearing scheduled on 10/7 at 11 a.m. Eastern in the Tallahassee courthouse. So we shall see if he files that. That was filed on the 11th. So he has 3 days. He cannot file. Ooh, I do have to do my stream on his documents because they are just fun. He is not allowed to file electronically. So, but I will cut that part down and I will put it as a separate video as well. That's the only update in those cases. Let me check while we are here. Florida and Orange County and see if there's anything in the Megan and Tug and Jeremy versus the Lips family. Oh, come on. Search. Court record search. Leslie Federico's. I think I searched it under her husband's name. Business torts. There is nothing. We read the motion to dismiss. There is nothing new in the Florida court in that. Let me check the their foreclosure. I'm just checking it all. Nope. The last thing was filed on 8/21. So all of his cases that are pending. So there's two. There's Seacoast National Bank versus Michael Federigo's, and there's Federal Home Loan Mortgage Corporation. That's all pending. JP Morgan Chase versus Michael Federigo's. Ooh, I'm just gonna do an update on his. That's nothing up there from 425. All right, guys, I am going to set up the stream. I was originally going to set it up to redirect to tomorrow night stream, but I will redirect it over to alternate juror AJ if she shows up. Is the stream already set up? And it helps if I spell correctly, right? Oh no, it's not coming up. Why isn't she coming up? Oh, there we go. Found it. New Hampshire versus Pam Smart. So I have us set up to redirect over to Pam Smart over on AJ's channel, and Carmen is going to be doing it. She'll do great. She always does great. All right, but that's scheduled for 6 o'clock. I will see you guys tomorrow. I might do a morning stream. I have not figured out whether I'm going to do a morning stream yet. I have a few things to go over. However, I am going to be doing a night stream, 7 p.m. tomorrow night. We are going to be talking about more fallout from social media and with a couple guests. Some you know, some you may not know, but all of which one of which I'm not mentioning their name because of the fact that I will believe it when I see it, because I'm so excited for this person to be coming on my channel. This person has never been on my channel before, but I'm so excited. I am so excited. But anyway, y'all have a great day. Go give AJ's stream a like. Give Carmen a like. Give Carmen some encouragement for today. And y'all have a great night. And remember, tomorrow's not promised. Be kind to each other. Don't call people names on the internet just because you disagree. Hug your littles, hug your family, and tell those around you that you love them, because we're never guaranteed another day on this earth. Bye.